Hello. Can I ask who I'm speaking to?
Joanna Edwards.
Oh, hello, Miss Edwards. It's Mr. Hussein here. Um, it's
Hello.
it's regarding the decision notice that you published, advised me of regarding the local authority Bradford Council's telephone
Yes.
directory. Yes.
Yes.
Obviously, I've just read your decision, and I just wanted to have a quick conversation with you regarding this matter because you make no mention of the fact that it was myself that had brought the document to your attention. Um,
Mhm.
can I ask why that is? Because obviously, I believe I'm taking exception to paragraph 38, which states during the Commissioner's investigation, the Council located the information falling within the scope of the request, some of which was.
They located that before you got back to me with the link.
Well, no, I, I don't think that's correct because.
It is correct.
Um, because why, if they had got back to you, then why did you ask me for a copy of it then?
They initially contacted me. I'll get the dates up now.
Oh yeah, sure.
Hang on, let me just get the case
Yeah,
up.
sure.
So they contacted me on the 22nd of August,
Okay,
asking for a copy of the directory.
just 1 second, please. Just 1 second. Let me just try to load up the case as well, so I have it before me. So it's a telephone directory. Now, just 1 second, please. Okay, I've got it here now. They're just loading up. So
Yeah. So they contacted me on the 22nd of August, and they asked me for a copy of the directory that you provided to us.
okay,
Yeah.
so
So I wrote to you then on the 23rd of August, asking you to provide me with a copy. Okay.
okay. So
Okay. And then on the 29th of August, on the 24th of August, the council contacted me again, and they said, following a deep dive review, I confirm I've now been able to locate the document in question, and therefore can confirm the council holds the information. And you got back to me on the 30th of August.
okay, well, is it not correct that I'm just looking at the dates myself now? I'm just going to the What Do They Know website. So I got a final decision. I believe I contacted your office on the 26th of June. Is that not correct?
Let me just check. 26th of June at 1:08 p.m.
Yeah. So I contacted yourself on the 26th of June, and
Yes,
I proceeded to provide you with a telephone directory. Did I not?
yes. And I
Okay.
didn't provide that to the council. I asked you for permission to provide it to them.
Yes.
But whilst I was waiting for you to get back to me with your permission, okay, the council contacted me and said they'd found the information.
Yes, but they only found the information once you had confirmed to them that a copy has been received but to you. So that
That is irrelevant, Mr. Hussein.
no, that is very relevant, isn't it? Because if they know that, because obviously they knew a copy existed. It's like it's not just one isolated piece of information. What had actually happened is that, as you know, and I think I've had this conversation with you subsequently, is that they produce this document annually. So they were they and then subsequently the file that they located was a recent version. I only had a copy of an old version, so they fully knew that they have this document. It's not something that requires a deep dive, does it? Because if they produce it annually, they what my position is that they attempted to mislead me by stating that they do not have this document. It does not exist, basically. And only when they realized that the question, the way I had worded the freedom of information request was one where they knew, then subsequently after I had contacted you, and obviously I made my contact with you on the 26th of June, publicized it on the What Do They Know website as well, you see. So they would have known that I do have a copy of that in my possession. So once they became aware of this, then they subsequently looked to state that, oh, we had a deep dive. I mean, that obviously makes no sense because the one that they provided was, I believe, I'm not sure which version 9 or something, which was this year's version. So how can you accept what they're saying, that we had a deep dive and accepted this? And we found it after a deep dive, because what they found was not my copy, was it?
No, they found the most up-to-date copy.
Yes, they found an up to date copy, which is produced annually. So that's the first thing, is that obviously they waited. If, for example, if I didn't raise this matter with yourself, would they have ever found it?
I can't comment on that.
Well, I mean, it seems obvious that they already knew the fact that they have a copy. They attempted to mislead me, and that's obviously, as you know, that's not correct. They should provide that information, and they attempted to mislead me by telling me that no such copy exists after 2 internal reviews. Only when the cat is effectively out of the bag, and the cat came out of the bag, metaphorically speaking, on the 26th of June, when you became aware of the fact that I presented you with a copy. Now, in the interim, you have asked for my permission, and as soon as you've asked for my permission, I've proceeded to, provide you with that.
I asked for your permission, according to our records, I asked for your permission on the 23rd of August,
Yes.
the 1926.
Yes, that's right.
And you got back to us on the, let's have a look. It didn't go onto onto my case until the 30th of August, because you sent it to ICO casework. It wasn't attached to my case, so I didn't see it until the 30th of August.
Okay, that's fine, but can you understand, soon as you've asked me for permission...
I do understand, Mr. Hussain. The issue, I mean, with regards to the late disclosure of the disclosable information within that directory, the Commissioner has found that the Council breached Section 10 of the Act. Okay, that's outlined within the decision notice.
Yes.
In relation to the part of the directory which the Council has continued to withhold, the Commissioner has found that has been correctly withheld under Section 40.
Okay.
Now, I don't know if you're aware, Mr. Hussain, but a decision notice is a legal document. We have no authority to alter or change a decision notice.
I understand.
So the only thing I can suggest is, if you are unhappy with the decision as outlined in the decision notice which has been sent to you, then you will need to appeal it to the first tier tribunal. Yes,
but the reason for my call today is I'm just gaining clarity of what you've decided, and just trying to understand whether...
We decided that the Council did hold the information,
no.
And they should have disclosed the part that they did disclose. They should have disclosed them at the time of your request, which is why we found a breach of Section 10.
No,
let's breach the time scale.
No, I'm not. I understand that. So you've upheld that. They upheld my complaint that it was outside of the time scale. Yes. What I'm taking contention to is paragraph 38. Which says, during the Commissioner's investigation, the Council located the information, and that's what I would like to focus in on. So I raised this complaint with you on the 26th of June. You asked for clarity on the 23rd of August, and
I've never passed your email or the copies of the directory to the Council. I never did that.
I know, I understand that, but can you understand that? But on the following day, the very next day. So the matter was raised with you on the 26th of June, and then all of a sudden they've exhausted 2 internal reviews. They've got no reason to be continuing to work on this FOI request, and then...
I understand where you're coming from, Mr. Hussain, but it's not unusual for a public authority to locate additional information during our investigation. It happens in a number of cases. It's not unusual.
But the reality is that it is unusual under these circumstances, because on the 23rd they became aware that I had presented you with a copy. Whether permission has been granted or not to forward that copy or not is irrelevant, and then subsequently they found the copy. Found another copy which is heavily redacted, and that was on the 24th. But what I take exception to is that why do you make no mention of the fact in your investigation that I had provided you with a copy that was available online? That is where
Because it wasn't relevant to my investigation. I was looking at your request for the most up-to-date copy.
Well, I mean, the thing is, the reason it's relevant for for in your investigation is that in your decision notice you make no reference to the fact that this document was available freely available online, and you as part of your investigation. Sorry, what's this? Hello, hello.
Hello, are you still there? I don't know what happened with my system then.
I think it was just like a put on hold, or there was music going on.
Oh, I don't know what
Okay,
happened there.
okay,
I must have pressed
okay.
something by mistake.
Okay. What I would like to say is that why do you make no reference to the document being available unredacted online?
Because it wasn't relevant to my investigation. That document that was online was an old version of the directory, okay? They only asked for a copy of that in order to help them locate the most up-to-date version. I was only looking at your request for information for the latest copy. So the fact that another public authority, a different public authority, had published an old version of the directory was not relevant to my consideration as to whether the council holds the most up-to-date version of that directory. I'm sorry that you feel it should have been in the decision of it, but it wasn't relevant to my investigation.
Okay.
I was looking to establish whether the council holds or held an up-to-date version of that directory.
Okay, that's fine.
Not whether they hold that directory itself, whether they held an up-to-date version.
Okay, that's fair enough. But the reality is that in the background, which is not being identified in your decision notice, there was an unredacted version freely available online.
Again, it's the same answer, Mr. Hussain. The fact that a different public
Yes.
authority had published an old version of this directory had no bearing on my decision as to whether the council held an up-to-date version of that directory.
I think
it's irrelevant.
Well, I think the relevant part is this, because you've accepted the fact that they are within their rights to redact the up-to-date version. However,
Yeah.
I think my issue is this, that why that's clearly, if you agree and we both come to the agreement that the document, the directory now available is the correct lawful one because it's appropriately redacted, then why is the fact that there was an unredacted version freely available? That's a concern, no? Because all that information is still personal information. Then it becomes a data breach issue, no?
Okay, as I explained to you in the recent email I sent you, I have raised that matter with the relevant people, with the council and with other people within the ICO. I can't comment on that matter. I was purely looking at your freedom of information request for a copy of the most up-to-date directory.
I think when you take
I understand from speaking to the council that directory shouldn't have been published by the other public authority, which is why it's been taken down now. But that was a separate issue to what I was considering was,
yes.
which was, and I keep repeating it, whether the council held an up-to-date record or an up-to-date copy of that directory.
Okay, so you accept the fact that it was a mistake for that directory to be available from
It explains to me that it was a mistake, yeah.
Okay, and so how does that mistake get highlighted?
I have raised that issue.
Okay.
I can't comment. I can't give you any other information about that issue.
Okay.
But because I'm only dealing with your freedom of information complaint.
Yes, I understand this, but can you understand your role and remit is particularly being compartmentalized? However, the reality is that the information commissioner who you work for needs to take a holistic approach of what's happened here.
I've already told you that I've raised that issue with the relevant people.
Okay, so what is the reference number that I can chase that up on then?
There is no reference number that I can give you. Your complaint has the reference number which is on the complaint.
Yes.
The fact you raised this other issue, I can't give you the reference number. I don't have the reference.
There is no consequences of this failure of this other local authority. How did this other local authority get a copy of this?
Mr. Hussain, I should point out that not every name that's published is potentially a data breach. My name is published every day on decision notices.
Yes, and as you may or may not be aware, that I'm looking to escalate another matter with your with the decision notice. It's this aspect of your and I think I've had this conversation with you or somebody else at the ICO. But why is it that your name is not data protected and the other names are? What's the distinction?
Right. The reason for our decision was set out within the decision notice that was issued to you.
No, I'm asking a separate question now. Why is your name not under the Data Protection Act?
My name is personal data, but just because information is personal data doesn't necessarily mean that that information cannot be published.
Okay,
It
so
depends on a number of factors, which is, as they are outlined in the decision notice, the considerations that are taken into account when publishing personal data are set out within our Section 40 guidance, which is quite a lengthy document. So if you're interested in what we actually consider in terms of Section 40 issues, and I would suggest you read that guidance, because it's not just one thing that we look at, it's a number of different facts that we take into consideration when we look at disclosure of personal data in response to an FOI request.
Okay, well that's fair enough, but can you understand this is a telephone directory that's been given...
The reason the PSNI issue was such a significant one is if you read the actual media articles on that, many police officers don't even tell their family they're working for the police because of the political sensitivity over in Northern Ireland.
Yes, I understand this. So, but can you understand that that Northern Ireland issue is a very pertinent issue, I think, because yes, of course, that people should be protected that are doing law enforcement, but there are exemptions under the Data Protection Act that prevent names of disclosure under, I think, criminal investigation or other exemptions where that disclosure should not have taken place. Other than that, my concerns are not police officers. My concerns, if you take a holistic approach regarding all my other complaints or raised in ICO, are social workers. Now, do social workers afford the same protection as Northern Ireland police officers?
What we consider, as I explained to you, I can't give you the specifics of every single case in terms of disclosure of personal data, because there's so many facts that we take into consideration as outlined in our guidance. What we took into account in your complaint in terms of disclosure of those names of junior officials is as set out within the decision notice. Now, if you are not happy with that decision, then you will need to appeal it.
I fully intend to.
Because information is personal data doesn't necessarily mean it doesn't go out.
Yes.
We look at each case on its own merits, and we look at whether, first of all, whether it is personal data, then whether disclosure would breach any of the data protection principles. And in looking at whether disclosure would breach any of the data protection principles, we look at things like the expectations of the individuals, whether disclosure is actually necessary to meet legitimate interests, and whether any consequences of disclosure outweigh the legitimate interest of the public in access and information. Each case is dealt with on its own merits, Mr. Hussain. If you're not happy with the decision in your case, you will need to appeal it.
Okay, and I fully intend to do so, but I initially started this inquiry with yourself, not with you personally, but with the Information Commissioner back in, I believe, March time, where initially I had looked to request the name of data protection officers. And at that stage, the ICO informed me that they're protected under the Data Protection Act. I, as a member of the public, just need to have a simple, clear definition of what constitutes personal data. Because from my perspective, I'm very clear.
I'll tell you what constitutes personal data. Data which identifies a living, identifiable individual. Now, that could be a name. It could be a property address.
Sorry, that doesn't help me. I'm sorry, that doesn't help in my definition, because as you can appreciate, otherwise, how are newspapers able to publish the name of celebrities? Because that's personal data as well, isn't it? And yes,
as I said, just because information is personal data doesn't necessarily mean that if that name is published, it's a data breach.
I understand this, but
For example, somebody might have consented to their name being published.
Well, do also
when you join a website like whatdotheyknow.com, for example, and you set up an account with them, it's public information. So you are essentially giving consent for your name to be published.
Yes,
it's
that's
not a data breach when What Do They Know publish all the names of the requesters.
That's correct. Yes. So when you choose to work in a publicly funded organization, you are effectively once again.
You don't consent to your name.
Yes, you do, because you're working in a public. Yes, you do.
I worked for a public sector body all of my life, Mr. Hussain, and I have never signed any consent for my name to be published
neither has a celebrity signed over consent for their names to be published. But because you, by definition, because you work for a public authority or a public organization, as you said earlier on, your name is not private, is it? Because your name is fully published.
It's still private information, but there are circumstances where names will go out. There are circumstances where names
Okay, all right. Okay, so let's bring this conversation back to this telephone directory. Now, this telephone directory has got names on there that are published and given to councillors. So those councillors represent me. They're my representatives, aren't they? Councillors represent me.
The councillors are internal members of staff. In the same way that most organisations would have an internal intranet site where details of all staff names and telephone numbers are published. A member of the public has not got access to that internet site.
Yes, but the only reason councillors are elected to represent me, aren't they?
Yeah.
So if they're elected to represent me and any information that they have, why can I not have it? They're not internal, they're the external representatives, aren't they? They're like the board of directors. All right, so I'm just struggling to understand.
It's going round in circles here. I can't give you any more information about why we reached the decision in
Okay.
It's set out in the decision of it. If you're not happy, you will have to appeal it.
I
can't give you
that's
any
fine.
more information.
I'm grateful for your information that you have provided. I appreciate you're not in a position to change the decision. As you've explained to me, the decision has been made. It's a lawful decision, and in order for me to challenge that decision, you've clearly provided me with outline of what I need to do next. The purpose of this call is not to challenge you in any way in regards to this. The purpose of this call is simply to gain clarity of understanding, because obviously I'm already taking a different matter up to the first tier tribunal, and it's basically the same thing again.
All I can say to you, all I can do is repeat what I've already told you, Mr.
You don't need to repeat it.
Names are generally personal data, but just because information does constitute personal data doesn't mean it'll never go out under FOI.
I understand this.
Circumstances where it will be withheld.
Yes.
There are circumstances where it will be disclosed, and each case is considered on its own merit. I can't give you any more.
And that's fine. And that's fine. And obviously, that clarity that I seek is going to be fully explained to me when I go to the first tier tribunal, where I will look to have this bashed out there. So I'm not looking to contest this. The purpose actually of my call was this paragraph regarding, your refusal to have made any mention of the fact of my contribution to this investigation, and my contribution.
As I've already explained
yes.
The fact that an old copy of this directory had been published by some other public authority had no bearing on my consideration of your request for an up-to-date copy of the directory. I've already addressed this, Mr. Hussain. We're going on in circles.
No, we're not. But you've not made any. You clearly categorized everything that's happened in this case in your summary investigation of the decision. So everything. It's when I contacted you, what I've said, and subsequently. But is this key element that has been missing from your summary?
It wasn't key to my investigation. You may think it was key to my investigation, but I wasn't looking to see whether the council held that copy or whether it published that copy.
Okay, if I did,
I was only looking at whether the council held an up-to-date copy of the directory which you found online on the website of a different public authority. It had more relevance to my investigation.
Okay, well, do you think if I didn't escalate, if I didn't provide you with that copy, then they would have never ever, nothing would have happened, would it?
I never provided the council with the copy that you.
But I provided you with a copy. But I provided you with a copy, didn't I?
Yeah, but I never gave that to the council.
But you made them aware of it, didn't you, though?
I made them aware of it.
Yes. So the cat was out of the bag.
When I made them aware of it in my initial letter to them.
Yes.
And they came back and asked for a copy of it.
Yes.
So then I wrote to you and said, can I give them a copy of it?
Yes.
But before you got back to me, the council had found the most up-to-date version.
Yes. But if I had never contacted you with that copy...
Well, I can't comment on that. I can't possibly guess as to whether... Neither can you, Mr. Hussain.
Well, no, I mean, I can because... No, I can. Because obviously they were being deceptive to me.
But I can't.
Yes,
I can't
okay.
say hand on heart that the council would never have found that up-to-date copy if I hadn't
Yes,
mentioned you.
yes.
You had
Well,
a copy. I couldn't possibly say that.
I think members of the public who obviously would be interested in this situation could make their own judgment. I mean, like I said, I will be raising this matter in the first tier tribunal, and hopefully an impartial arbitrator, such as the first tier tribunal, will equally can make their own decisions. Because I believe the only reason this is a very serious data breach, as far as I'm concerned, you're not willing to tell me what you, the Information Commissioner, are going to do about it. All you've told me is that you've raised it to the relevant parties. You're not even in a position to give me a reference number so I can chase this. So basically, it's been a whitewashing exercise as far as I'm concerned. But there's nothing further for me to discuss with you. You've answered all my questions, so I'll be looking to bring this conversation to a close. Thank you, Miss Edwards, and thank you. Yeah, goodbye.
Thanks, bye.
Goodbye. So as you can see, Miss Edwards here, Joanna Edwards, has not given me a clearer definition of what constitutes personal data. When people make it arbitrary, or will make a decision on a piecemeal basis of what is personal data, can be published, they should be making it clear to me what is publicizable as personal data. Effectively, what they're trying to do is they're trying to use the Data Protection Act, which is used to protect members of the public that are members of the public. They're trying to use that law in order to safeguard and protect officers. Officers, by their very definition, have to give their name as part of their job, like police officers, like social workers, like any kind of officer has to, by definition, of openness and transparency, give their name. The Information Commissioner is effectively making a mockery of the law by stating that also is personal data. It comes under this definition, because now you have celebrities that can easily make the argument that we've not consented to anything. Like Miss Edwards was saying, I didn't consent to anything, or I didn't sign over anything. It's just basically making a mockery of the law, isn't it? They want data protection for themselves and their officers and everybody else. That they just want to make it like this a term that's all up in the air. It should be clearly defined. I have a clear definition of what names come under the Data Protection Act. Any officer's name is not covered under the Data Protection Act simply because they have chosen to work in a public when they choose to work in a public place, all right, under a public authority, their name is by definition not private anymore. So for me, as a member of the public, to go on a What Do They Know website and give my name over, she's saying that makes it public now. Okay, I don't have to give my real name to join a What Do They Know website, but can you understand? They have to give their real name in order to work as councillors, as politicians, as members of the public. So as members of the as public officials. So if they want to hold a position of officialdom and authority, and to say that we've got positions of authority and our statements should be valid in a courtroom of law, then quite clearly, it's like if my neighbour makes a statement in court, does that have the same value as a police officer who makes a statement in law? No, because that police officer is a professional, and therefore their authority as a professional would be a higher value than any Joe Public. However, any professional has to give their name and make it public. They want to use the Section 40 of the Freedom of Information Act to state that this is personal data. Somebody's name is personal data, and if the Information Commissioner has taken this approach, it's a wrong approach to take. Now, in relation to this very serious data breach that they're talking about in Northern Ireland, the PSNI data breach, there are clear exemptions under the Freedom of Information Act that say we're not going to be disclosing this information of our police officers, particularly in Northern Ireland, because it puts them into danger. So there are exceptions that should not have happened, all right, but they cannot use that exemption, that exceptional circumstance, to say that no, because the police officers in Northern Ireland are in danger of their name being publicised, then therefore no name should be publicised. Social workers' names should not be publicised because they don't want to have their name publicised. And this information, the data protection officer, their names shouldn't be publicized as well. So they're basically making a mismatch of this arrangement in order to benefit themselves at the expense of the public that they're meant to be serving. So And this is not unusual circumstance under my investigation that the local authorities or the public authorities look to hijack the rights of the people that they serve. So, for example, the health authority are meant to be helping members of the public, but what they end up doing is helping their fellow colleagues with health services such as mental health services. So they'll get their own colleagues to get those services as officers before providing those services to the people that need them and the people that they're entitled to have service to. So all officers are by their very definition public servants. This is a public servant, and so she wants to argue, or the Information Commissioner wants to argue, oh no, it's on a piecemeal basis. We will decide depending on the circumstances whether that's public or not, whether that's personal information or not. And it needs to have a clear, concise definition, as I would argue. Anybody who's not working who's not an officer, who does not hold a professional position in the system, his name is not private, because they are effectively working in a system. So anybody working for Bradford Council is not a private citizen because they're working for a public authority. Anybody working for the NHS, anybody's name working for the NHS is not private information, it's public information. Just as if I was to start a company and become a company director, my name would be then public. All right, it's public information. And this is the whole argument here. And so I'm glad I've had this conversation, but you can clearly see that they're being very deceptive in the approach that they're taking. They're compartmentalizing things. They've effectively helped the local authority whitewash their failures. She's explained to me that the local authority accepted that another council, namely I think Keighley Council, had publicised this document. So this failure I brought to their attention, and the ICO effectively whitewashed this, and by not making no mention of it in the decision notice. So this is completely disgraceful of the ICO. But you can see that this is what they're trying to do. The ICO does not work for the people, does not work for the members of the public, namely Joe Blog, the average Joe Blog. They work in the best interest of their colleagues, their paying members, namely the public authorities, and they will never ever reprimand the public authority for their failures. And the position of the ICO, Information Commissioner, is simply to help whitewash any complaint that anybody looks to bring against their partners and associates, the public authorities. If, however, it's an individual person, oh yes, the authorities will come after that in Joe Blog individual person and say this is all against the law. The public authority can effectively do no wrong, and through this exercise it's clear and evident to me that the ICO is in collaboration and collusion with the local authorities up and down the country. Their job is simply to work in their best interest. And what is interesting is the Section 14 vexatious requests. This is a silver bullet or a get out of jail card that the ICO has helped through Alan Dransfield to create in the First Rate Tribunal to whitewash any FOI request. The local authority could have simply said, no, Section 14, we're not going to give you this information. It's considered vexatious, and I could have been denied this information through Section 14 being vexatious, and that is a silver bullet that's been utilised up and down the country. But in this particular case, they've not used Section 14. They're using Section 40 personal information, when on the conversely, they've gone through all my personal information as a private member of the public. Only private members of the public, private individuals, should have their data protected as private members of the public. Ratepayers, council taxpayers, voters, those names should be private. But as clearly experience has shown me that those names are not private, they're quite happy to hand those names over to any prospective person that comes and tries to become a councillor. They'll hand over their names and addresses. That's not personal information, but the name of social workers and the name of people that work in the council, that's private information, and they've redacted it. So this obviously matter needs to be elevated to the First Tier Tribunal. My only fears are that from my own personal understanding, the local authority will simply buy off the First Tier Tribunal to whitewash this situation, as they have proceeded to do with the Information Commissioner. Absolutely horrendous, absolutely disgusting in the manner which which they are dealing with this matter, the Information Commissioner clearly compartmentalized this in order to say, limit the scope of what I'm looking into. I'm only looking into this little bit, whereas the Information Commissioner should have taken a holistic approach and said, well, wait on a minute, why is this directory of being publicly available if we accept the fact that it needed to have been redacted? Do you see how they're playing word games and discombobulating the situation by narrowing the focus when they want to, extending the focus when they want to, or the scope of the inquiry in order to facilitate an outcome that's predetermined or is pre-purchased for the best interest of the public authorities that they're looking to conspire and cover up with. So exhausting having to deal with these lies and deceptions and